I'm Keith Becker, the General Manager for Deedee's. The Tenant Protection Act, AB 1482, is a fairly complex new law affecting all of California, but it can be broken out into 5 major subject matters. Today, on this segment, I'd like to talk about rent caps and vacancy decontrol. First things, we are so very early into this process that we're going to be working out the details for months and years to come. This is my best understanding and best recommendations as the situation stands right now and may be subject to change. Secondly, every situation is unique, so if you have legal questions, please contact your attorney. As a recap, AB 1482 is a rent control ordinance. It's a rent control law. It caps the amount of rent increases on those properties that are impacted to no more than 5% plus CPI on an annual basis. If CPI exceeds 5%, the cap is a maximum 10% gross. It would not be 12% if CPI is a 7% increase. Additionally, those properties that are impacted, just cause applies, meaning it's a very short list of reasons why you as an housing provider might request or require a tenant to vacate the premises. And in some of those instances, you would be required to provide to the tenant relocation costs. If you have a property that is not exempt, and we've spoken about the various exemptions, and there are quite a few, we've spoken about them in other segments, but if your property is not exempt, it is mandatory that you put into your rental contracts this verbiage using these words, and it must be into your rental contracts in 12-point font. Whether it is new contracts or whether it is contracts that were in place. For new and renewing contracts, it must be in place by July 1st of the year 2020. For existing contracts, it must be in place by August 1st of the same year. Let's talk about the Consumer Price Index, which is the 5% plus. This is the plus calculation. Consumer Price Index is a measure of inflation. It is established and measured by the Bureau of Labor Statistics. In order to get the information, you can actually get this report. It is available in manual printed form, but it is more importantly available online. The easiest way to find it specifically is to Google Bureau of Labor Statistics CPI Western Cities Summaries. That will bring you, this is the page you're looking for. And it's Western region because California is in the West. It does us no good to care about what rents or CPI is in St. Louis, for example. You're looking for this page. This page is the Bureau of Labor Statistics archives, and it has information going back months and years. And what you're looking for is the report for April of whatever year in question. Because while there's measurements that go on throughout the year, August and December, the only one that matters as it is related to AB 1482 is the April percentage changes year over year. There are certain metro areas in California that actually measure specifically for their individual metro areas. San Francisco, Oakland, Hayward, Los Angeles, Long Beach, and Anaheim, Riverside, San Bernardino, Ontario, and San Diego, Carlsbad. Now, Los Angeles reports on a monthly basis. San Francisco reports on a bi-monthly basis, but they report on even months. So, February, April. Riverside and San Diego report in odd months. So they don't actually even report in April, they report in March. But given that this is your April report, this is the column you're looking for, it will reflect the most recent report for Riverside and San Diego, which is the month previous. That's the number that you need to work with. And for example, if it said that the increase year over year was 2.9, your rent increase is 5% plus 2.9, a gross 7.9% increase. What happens if you're not in one of these areas? Because these are specific to counties. If you don't fall within the counties impacted, then you do not fall into one of these metro areas. In that instance, you're going to be measured by West size A or West size BC, and your county is established in which one of those categories, A, B, or C, dependent upon the population of the county. So, rents cannot be increased more than twice in a 12-month period, and it cannot exceed the allowable annual cap. For example, let's say that as of January 1st, you increase the rent 5% because you know you're allowed to increase 5%, and then come July 1st. And why do I say July 1st? April's report is released in May. In order to be able to institute an increase, you have to actually provide a 30-day notice. So when it's released in May, you give the notice in May, you give 30 days notice, it wouldn't be able to go into effect until July 1st anyway. So let's say you institute a 5% increase in January, you institute another incremental increase in July for that 2.9 or 3.1 or 5 max to adjust for the difference. You can only do adjustments and increases twice in any 12-month period, and it cannot exceed the cap. When a property is vacant, this calculation no longer applies. If you have a property that is vacated, you can adjust it to whatever the market will bear. So if you've got a tenant who's been living in the property and it's a 3-bedroom house, and the 3-bedroom house is worth $25, but the tenant's been paying $1,500, you're not required to increase the rent to only $1,600. You can actually increase the rent to whatever the market will bear at that time. However, once a new tenant moves into that property, all of these regulations in terms of rent caps once again apply. There's a unique situation associated with how AB 1482 is written to establish what is effectively a look back. The writers of this law did not want evil landlords to increase the rent more than the allowable amount in the latter part of 2019 before this law goes into effect as of 2020. So they said the benchmark is March 15th of the year 2019. What was the rent as of March 19th, 2019? If you raise the rent more than the allowable amount, let's say you've got a 7.9% cap, but in the latter part of 2019, you raise the rent 10%. As of January 1st of the year 2020, you have to adjust the rent down and notify your tenant. You adjusted the rent back down to whatever the allowable cap is. You're not required to pay back the overage that your tenants may have paid prior to January 1st. But going forward, you cannot charge what you had previously established. You have to dial that back. And for a very clear and serious reason, don't just think you can skirt this. Make sure, if you're required to dial that rent back to make sure you're in compliance with CPI, do it. Please contact a property management professional or a real estate agent if you have questions about this. It is complicated, it's going to get more so, and they will be able to help. And as I said before, I'm not an attorney. If you have questions, please contact your lawyer. These are the links, both for AB 1482 itself, and I gave you the Google recommendations previously. If you wanted to, you can type that in and get right to the information yourself. I'm Keith Becker from Didi's.